Welcome to VOS Social Media Review, your weekly platform for insightful discussion, bold analysis, and the stories shaping our society. Join lawyer Shilon and engineer Mengat every Sunday at 8 p.m. Sierra Leone time, streaming live on all VOS social media platforms. Stay informed, stay engaged, stay connected with VOS.
Hello. Good afternoon, good evening, good morning to everybody. Today, now April 25, April 25. Am I right? No, April 26, I'm correct. Excuse me. April 26, 2026. Welcome to una all, wherever una den at the world. This is VOS television coming to una live. And for una, we know how the program is conducted or runs. We get 2 good hours of what we expect for be very engaging. So we welcome everybody with a listen, or we plan for tune in, for make as much contribution in terms of suggestions and comments that they're able to do. So today, we come across with my co-host, Mr. Victor Mengot. So we could talk about current affairs in Australia, or trending. We can use the phrase trending events, issues that are trending. But we'll be talking about issues that are trending in Australia, and then we go welcome people. And as soon as I know, the lines are open. So you don't have to be invited, but from time to time, we will remind you now, say the lines are open, you're free to call. So let me get the numbers then, we generally can put on the screen. About, where they come from, we get different platforms then from which we are being carried. You then carry on YouTube, then they carry on Facebook, then they carry on Twitter, that is called X now. X. Not to X now, X. So then we'll get website, we'll get radio station, and all of that. So let me just go through. If you want to get through on YouTube, Facebook, and Twitter, formerly Twitter, now X, just go to VOS television, .com, or VOS television, you will get through. If you want, we'll get to the website now, vostelevision.com. If you want, you can also reach me at the radio station, which is 91.9 FM. For be able to reach me at 91.9 FM, you get for going at the Google Play Store or the Apple App Store and download VOS app. The station, we station the app. That way they will take you directly to we, and you'll be able to listen to we over the radio. And also with the inquiry on to what you call Twitch TV. That also you'll be able to reach we. Then we also can try to bring in one other thing, where not necessarily a platform for Yeriwi, but now for just informing about the non-profit organization aspect of VOS, with the run which you call a helping hand. And that helping hand, then we call it the Diaspora Scholarship Program. That scholarship program, now VOS, they run them for gather money or raise money for picking everyone go school, but they're not able to continue because the financial ability not there, or the financial resources not exist for them to continue. So we always appeal to una, or plead to una, say, if you are able, please just contribute whatever you can. No amount is too small, no amount is too large, but we need for education to begin them, because it's all good for the country. The more we get educated people, the better the future will get for the country. So with the plea to una for say, if you're not able, just and contribute to the diaspora scholarship program with VOS to run. And then if you want to know more about it, just call a VOS station, then go give you more explanation and tell you all the ins and outs or answer any question you get. Okay, so I'm here today with my co-host, Mr. Victor Mengot, as I say. And from there, we'll go start dealing with the issues we want to discuss. On a broad scale level, the issue that we want to deal with, the broad issue is Sierra Leone's National Security Bill, the Ecsl Restructuring, the Ecsl and the Electoral Commission, we refer to. Normally they refer to it as Ecsl, Electoral Commission of Sierra Leone. Then the restructuring of it, and then the census data and the road to 2018 general election, which is the next presidential or general election. So with that said, let me pass now over to my co-host. We will give you more detail as to what the subheadings are going to be, and then we will take them point by point by point, or heading by heading by heading. So to you, Mr. Mengot.
Well, Fambulem, in a good evening, good afternoon, or good morning, Usayide. Today, we get two main topics and they're interrelated. One of them we'll start with first. Now, the National Security and Central Intelligence Bill, where they go through Parliament now. And the interesting thing about this bill, they put this bill before Parliament at the time where the opposition members of Parliament, then they're on boycott. And today, we go and trace who in Commonwealth campaign, national intelligence and social security and central intelligence bill and everything. So we'll look at how we come about this, the laws that will begin as alone. And this bill now, where the cargo Parliament, it brings some new things them, and we'll try to highlight some of them things that we deal with. A new force where they talk about special protection force. We talk about issue where relates to how government they gather intelligence information. How also we they look at issue for do with warrants, how then they access citizen, and the powers them of the various security agencies. The second part, where we're in an ongoing conversation, we will not say the moral guarantors them being Kana Salon. We'd always use this term moral guarantors. If fine law make people them know what thing they mean by moral guarantors. If you take them literally, moral, now things that we deal with ethics, standards. So you go say, now people already guarantee that. But in the basis of this negotiation where we talk about when between the government and the opposition, moral guarantor mean like mediators. Me go I call them mediators because then people are some of them insane. People that we can observe the election of 2023. And where the election they done, draw been take place. The opposition say they're not being counts done, where they give the result, so they not accept, so they boycott Parliament. President go na Parliament, where go do state opening after they don't swear where for the first time we go na Parliament, the opposition not been there. And he's a bit worried because governments now both the ruling party and the opposition. So as then they say when they angry and the moral up ground say, oh well, this na President Bio. Now him been say, let them look into elections management system. And at the time when he say for look into elections management system, he talk about all the elections then from 2023, the Huawei controversial, 2018, 2012, 2007, to 2002. And we propose say na in vice president when Dr. Jules Jallo we be now working at the UN. We got experience in that matter there for lead the whole thing. But then the moral guarantors, one of them, the American embassy, come in and said, no, if you want to get some fairness in this whole process, let this inquiry not be led by the vice president. So now then they bring about what we call Bintumani 3. What's in a Bintumani 3 in a conference where they go, where the APC and SLPP then go there, then go get this agreement of peace and national unity. Then I for say, okay, one of the key things of that agreement there, now for say them for look into this electoral system and constitutional review, we don't bring all this thing. So now on that basis, the APC go back to parliament. And some of the things that we've been in that agreement for national unity, now for say because them for paying them backlog for the time where they no go parliament, they also for look into cases the way they feel in a political nature, they for drop them cases and then they also get list of people the way they say them in put in a prison where they for relieve, them for actually free them. But central to all this, the most controversial side, that is agreement of national unity. We'll go come to that. But let's start first with this national intelligence. Kyoki say, if you don't know who side they go, if you know side you come out. And we want to talk why intelligence is important. In the past, as we know, immediately after independence to the republic, waiting at the organs they will be get for intelligence. We been get MIB when a military intelligence branch, and waiting to that they been set up, mostly for deal with sojaman them and other subversives, and also because when the sojaman and they take oath, the oath when they take, now for defend the territorial integrity of a country from both internal and external aggressors. So somebody who come out can cause kuskas in our country, or if a set of security personnel like who be not get experience with Boku coup d'etat. So MIB na them in there for that. But for we the civilian, police been get special branch. You get police special branch, then they get CID, the Criminal Intelligence Department of the police. So now they are and they be happen. So after all the tenure of Kulala in our country, we know say in 2002, President Kaba, they will go sign that peace accord, the Lome Peace Accord. We make so we been say well done. So after that Lome Peace Accord day, Nine set up the Office of National Security, ONS. So now a new institution will be come up from 2002. So waiting ONS have been a key role. Under ONS, you get the National Security Council, where the ONS been get the Director General, where enroll now for look at everything for do with security. Then we get National Security Coordinator, the Security Coordinator. Then the National Security Council now include the Security Coordinator them. Now the central body, where I mean the main body, where now they coordinate all national security policy and operation, both relating to civilian and the one and the forces. They also, that body there, Section 31, now give them a mandate. Because you know, so we get boku private security there at all. You know, because of the crime they went on boku na the tongue, boku people and they set up private security companies them, where they either provide security for individuals or companies or businesses. So they want that they need to be regulated. So now the Office of National Security, now they do that. Then they also get investigative powers for those sting operations, you know, and all that and they. So after 2002, this government they now repeal that act in 2002 and come with a new national security and Central Intelligence Act 2023, which is less than 3 years ago. Almost 3 years ago. Now we don't come with this National Security and Central Intelligence Bill in 2026. So what we want to do in this program today, now for look at provisions in this bill, will not be exists or existing provisions where they don't give more teeth or they give more roles than the, but we look at in the context, say, when do they make them here? You have to think about citizens' protection as guaranteed under Section 3 or Chapter 3 of the Constitution. What's in that Chapter 3? Now they deal with citizenship rights, things to do with freedom of expression, freedom of assembly, protection for the rights of property and all that in there. So that's the way to one can look at. And before I go, let's see if my colleagues get anything for say. So we'll start now with one of the first thing where this one bring, and we're going to go through the law them and explain telling her how this thing come in and what to for expect. Over to you, sir.
Continue, Mr. Mengot. I'm not getting a comment at this stage.
Okay. Now, one of the key things where this bill bring, now a new agency, completely new agency, where they call State Protection Service. People then begin wonder, say, what's in this State Protection Service? Because we get Office of National Security, we got all that, and why the need for the State Protection Service? So let's go into the bill. Let's see what's in that State Protection Services Day, and I go refer to the law, what they say. Then they come under Section 32 of the new bill, which creates the state. And then the other interesting thing, the Central Intelligence Committee, we've been there under the ONS, instead of being a committee, they now make up a separate agency. So for anywhere in America, it is equivalent to like in a CIA, Central Intelligence Agency. So we have don't get we own CIA. But now go to Section 32 of this national waiting, and a very worrying waiting and say, because even the parliamentarian way then have been a question. So Section 32, subsection 1, it says there shall be established a state protection service under the authority of the president, which shall be responsible to provide mandatory, you're going to say mandatory, proximity protection. What do they mean by proximity protection? Close protection. And who are them people are there for provide this close protection for? He said the immediate family of the president and vice president, and also he said their facilities. Where for me say their facilities will be if they be involved in business, they get business deal or they get other properties them, right? And then they talk about other categories of people that where the state protection services will protect. Former presidents. So in other words, let's say even when the current president and vice president, let's say they're not there after 2028, because they are former presidents, they were still entitled to protection under the state protection services. And when you talk about protection, it means you get for train them, you get for pay them, you get for arm them, because they protect somebody where you not get means of defense. Former president, former vice president, the speaker, the chief justice, ministers, they say visiting heads of state, and other designated very important persons. Now that's the one way, now very serious, where you say designated very important persons. Who then are this very important person? Who will determine it? We see we MPs themselves, because they don't put them on that and say, power we not so so we say not so very important persons. MP then say, now for define now, let us be covered. So when you look all the people they are within the talk say for provide close protection services for, in perpetuity, just think about the burden in terms of finance and personnel. Because right now the protection of them people and they now security forces seconded from existing force, like the military, the police, and the army. And even the president, he get the presidential guard. So, waiting at the need for these special protection services. Okay. It talk about waiting that this service get for do. Now they coordinate and plan all the protection for them people here. Now they talk about waiting and go need for protect the people them. Now they analyze threats to the president. So in other words, this special protection services feel say the president is being threatened. Now they go able know waiting for do. Now they go also go deploy protection, and when I say protection, you mean human protection and also related technology. So now we get this cyber crime law where them you don't get, which means they get way for use intelligence, artificial intelligence or electronic surveillance for probing to anybody where they feel say was threatening the president. Then they say this protection service go get a committee, and this committee, now committee will go comprise of the National Security Coordinator, when the president they appoint, and then go be as chairman. And other than the people that were there, the chief of defense staff, when at the Agbagba, now the army, the Director General, Central Intelligence and Security Agency, the Chief of Staff, Office of President, the Director General, Ministry of Foreign Affairs, the Financial Secretary, the Director of State Prosecution Protection Service, now go be Secretary. Also, this SPS, this State Protection Service, can co-opt anybody. So it means sometimes they get a party people them, they can co-opt them into these intelligence services. Whichever party are not limited to one party, because we make law. If one party come, if this law pass, the next party will come, it go use them. Just like how when they be initially been passed the Public Order Act 1965 under Albert Magai, the APC government will come, they use them, especially with Chaka Steven. The area will deal with seditious libel. It go on for a long time before President Bio now can say they for remove just that clause there, but that act they still there in place, the Public Order Act, because now they use for convict Madam Zainab Sheriff today. So then they talk about the State Protection Service for do all anything in there. Then let us look at the director. Now go be head of the secretariat. So that director there, now the president get for appoint him. And he said if I be a citizen of Sierra Leone, enough for be enough for convicted of any crime or including fraud and this, and enough for be active member of any political party. Look at the interesting thing. Enough for be a serving member of the Republic of Sierra Leone Armed Forces or Police Force. And as usual, we're obsessed with qualification. If for all the master degree from a recognized university. And it will serve for 5 years and eligible for reappointment in another 5 years. So let's stop here. Then we will continue. Let's see if my colleague get any comment or question for ask.
Yeah, thank you very much, Mr. Mengot. Well, first and foremost, the problem I think they're going to have, the need for Telwe, because if the national security Central Intelligence Bill of 2023 is being replaced. So it will be good for we for know, because they are setting aside the entire act. So it will be good for the country for know, waiting that the reason why then the change, then they set aside the whole existing law, and then they try to replace them. And number two, then need for tell we, unless you know, waiting at the new stuff them, when they include on this bill, then the next thing is, why are these new issues here necessary for being included in the whole thing? You know, because some of them things didn't sound very good. But the other thing we have to take into account, it seems like to me, this cost a lot of money. All them designations there, where then they put, that will run into the hundreds, if not millions of dollars. Because in the beginning, now remember now, this go get more and more expensive. You know, so now if all them people are, where they want put under, get all them protection here, it takes staff for run whatever ministry will be responsible. So budgetarily, just by sheer financial ability to provide them protections here, their privileges there, how are we going to do it? What provisions have been made? What projections have been given to us for us to know what the country may be looking at? Because when they talk about a country where you not get the ability, we still go through tremendous financial strain. So in the order of priority, you just wonder what gave rise to all this new awareness of all the security protections here. What they talk about, what they want to have to provide. You know, and if the existing protections are not adequate, at least therefore explain to we. But then Mr. Mangot used the word perpetuity, and this meaning once they all the people out and give them protection, the protection now until they leave, until they die, throughout their lifetime. So there is no definite time when they will stop. So you just continue. When they die, of course, that privilege is stopped. But it's not even clear, because there is some indication, and Mr. Mengot will clear that for we, if at all, then say protection to some of them people and their family. So if the person dies, are their families still entitled to the same privileges and protections? The bill doesn't seem to be very clear. If Mr. Mengot could just make we understand if that's the case, because some of the protection extend to the families, or the protection extend to the family to the extent that the primary person is alive. When that person dies, the privileges cease. So, and all the other thing I can always talk about, we laws are very broad, they are very vague. They should be constitutionally tested. The reason why I keep emphasizing constitution is because it makes sense. Say, for example, the Zainab Sharif case recently. That case was tried in the lowest of the echelons of the legal system, the magistrate court. Personally, I was surprised that such jurisdiction was given to a magistrate court, because you talk about at that level there, somebody in constitutional right is fully attached. So meticulously, a trial for entail a whole lot of stuff. Okay, so now there is argument about whether, in fact, on the Zainab Sharif's case, whether a crime was even committed. You know, because I see one of the salon lawyer them, where it is if you were to cheat, if you were to do this, because it's all conditionally based. If you say that and there is no specific person or place or thing that you are referring to, this lawyer, they say, in fact, at a trial, if it's objectionable if you were to cross-examine someone and say, if you are to do such and such and such. As soon as you phrase the question like that, that question is subject to objection, because it's highly, highly, highly speculative when you say if. So whether in fact there was a crime committed with respect to what this woman said, the reason why the case should be appealed, it's time for the courts to be taking definitive stands on some of the laws here where the parliament they pass. Because the parliament wouldn't pass the law, not to their job for interpreter more. Whether they pass and they don't pass, it's up to the court for interpret, for make sense, or for fine tune, no matter how badly written the law was. Now the court now get for do the chiseling and do everything for make sure the law is smooth and fair and effective and efficient. So what the courts not going to able to do nothing if the cases are not taken to the courts. The court themselves can't go around fishing for cases to be brought into the system. So it is in everybody's interest that all the legal argument, because we've had so many good arguments on the Zainab Sheriff case, which apply to some of the bills that were in the President and Parliament, it is important that some of these cases, for the good of the country, are taken to court to get the court to be involved to challenge them, knowing full well that we got for bill. See, this is the thing. People say, oh, well, I don't trust the court. Well, then we're not going to get a system. No matter how untrustworthy the court is, or the courts are, we get for bring them cases here because I saw the system to work, for make sense out of them. So Mr. Mengot could point out a lot of irregularities on things that were contradictions, vagueness, and some of them bills they come up with, because the people who they come up with them, some of them are not lawyers. Even if they are lawyers, the motivation for coming up with the proposal now is different. But these cases must be taken to court, because some of them, now the court no more get the power. And when I say taken to court, even if you lost at second and first instance when at the magistrate court, I will assume that the matter is going to go up to the High Court, I will assume. Now, I hear one of the lawyers in the talk say the Chief Justice should do this, should do that, like in the Zainab Sheriff case. I think that's a bad procedure. Leave the Chief Justice out of it, because the case might end up landing before him. So if you begin to give your opinion now and begin interject or begin and get involved, it will spoil the process. So we just think, say, some of the laws there need to be challenged. I keep saying all the time, for the good of the country. Let us get it clear, because Zainab Sheriff, in case he raised a lot of issues, a lot of things that the court needs to really clearly define, like this particular Public Order Act, the section under which she was charged. How do you prove a case without injecting, if we talk about clear law, leave politics out of it? You know, and we cannot afford a system where the law becomes what the party in power or the government in power says it is. You can't do that. The law for serve be above and beyond the convenience of a political party. You know, I can use so many examples now in the United States, but what would you see the courts, they rule against the current presidents almost on a daily basis. You know, because you oath as a judge now for be loyal to the Constitution, not to a party in power. And I even see a video recently where even Gambia, where they close to the president go to, I think, the cadet parade at the police, where you get some graduates then. And part of his speech, he say, the police should, the primary responsibility, now loyalty to the Constitution and the people. This is in Gambia now where the president, they say that. I think we police the need for you that more and more and more. Then loyalty not for they to the party in power or the government in power. The government in power also is subject to the laws of parliament. Because if one part is above the law and another part, the rest of us get for subject ourselves to that, it's self-defeating. So we keep revisiting then bills they bring in and bring in and bring out. Let's just drop one thing, add to them, but not and get rid of an entire act for replace them. You know, we're not even talking about an amendment. When they talk about repeal, then they repeal the whole thing. So for me, again, like we always say, or I always say on this show, we are not anti-government. We are pro-Sierra Leone and pro the people. You know, because when you guarantee one person a right, you guarantee everybody else in right. It's a concept where we Africans not able for taking and digest yet. Because we just feel so once you get the power, you must control speech, you must control movement, you must control activity, no matter how arbitrary it is. But it is not the right thing to do. You know, we need for really try to get up a system. And no one less than those in power, that therefore set the stage. You know, when laws are passed, let those in power decide or for certain example by trying to comply or obey. Or not putting ourselves above the law. And then this thing about trying to draw make laws because no one forgets some immediate undue advantage. Not only advantage where you're not even due, but because you get the power, you want to make all kind of bad laws. Well, one thing we can tell anybody, and the interesting thing about most of we people in the power, they're very young. Some of them, even they were born during the early stages, in the 60s, after independence, in the 60s and the 70s, and even up to the 80s, they were very young. They don't quite understand political history. That some of them, laws that are being passed for immediate gratification or for short-term gain will come back for haunt you or haunt the rest of us. And that doesn't slow down progress. You see? And I think there has to be some kind of education with them for begin conduct for parliamentarians. Them. Let them understand what their responsibilities are. Not every bill brought to parliament should get assent or consent or agreement to be passed. Some bills should be, proposed bills should be challenged and denied. You know, and again, if we want for make the system work, the Constitution needs serious reviewing. I've been pointing this out. All the powers keep is going to the direction of the executive. You know, a system that can just take a judge off a case and make an ambassador or force him to go into retirement, we for nothing a bad system down there. No government for tolerate that. So but people don't get the courage for say these are bad laws. So you take a person, if you're a judge, the government shouldn't have the power to just force you into retirement. They shouldn't have the power to just force you for take a leave when not to the time for take them, and then take you out of that position there. But tactically, it might sound efficient, effective. It can get the goal for which you to do that. But the country suffers. It does no good for the country. It will help one or two people in a short while. I don't think anybody with that kind of legislation and the benefits in the long run. It hurts everybody. Because even you would help for past bad laws. It will catch up with you or your loved ones. You know, you are not going to remain, even if you remain in power, you're not going to live forever. So we have to think about anything in this. So these are some of the things. So I think we will be grateful we get somebody like Mr. Mengot, who seems to understand the policies they have very well, and more attention to be paid to him. And I think, like the opposition, we not get more heavy lifting than the other side with the power at the hand. So we're not for do more consultative thing. But the other problem is, why someone, I don't have to be an advocate for my colleague or my co-host, but this is a man with a lot of knowledge. What is the opposition doing? Not even raising some of the issues the way they raise. We're not to the media get for do that, and then for do that, and then for do their homework. But with that said, this is not just personal observation, just with some ability to foresee what will happen down the line, so we can prevent all of that. But if we pass laws them like this national security and central intelligence bill we would try to pass, we have to ask, what is the purpose? Why are all the existing laws being set aside? Why are we adding extraordinary conditions now in terms of protections for high-level government officials? Now, everybody knows the former president should be protected. Certain people should be protected, because you've been a president, you deserve protection for the rest of your life, okay? And maybe one or two top officials, it might make sense. But if the purpose of that is not to genuinely try for protect that office there or the individual, now for try for gain an undue advantage, for provide a counter force to the existing force, you're hurting the country. So my thing is, I just question the motive behind some of the legislations there. So back to you, Mr. Mengot.
Oh, thank you very much. You raised an issue. Should I clarify the point as to who and who is entitled? And I remember I used the word in perpetuity, which means correct. Yeah,
indefinitely
till thy kingdom come. Mm-hmm. Because when they make the protection, you get two categories. The first priority, now the immediate families of the president and vice president and their facilities. Then under A, subparagraph 32(1)A. But then you get 32(1)B, where it said the following special categories of persons: former presidents, former vice presidents. So I assume, say, from the way it's written, the special protection force go responsible for the president and vice president in and out of office. The other people then we did it, I think say them protection whilst they hold office. When I like the speaker,
does it say
the Chief Justice?
But does it spell that out?
It's not explicit. It's not explicit.
Yeah.
It's not explicit. It said the Speaker, the Chief Justice, ministers, visiting heads of state. Where the ambiguity is, other designated very important persons. Other designated very important persons. Who designates these very important persons? And
that's
what's the definition? And what's
on the eyes of the beholder? Yeah, what's the definition?
And yeah, okay. So that's an ambiguity in the law. The other thing where probably it will be an omission or willful submission. Now, when it comes to the director, right? It said the state protection, that's 36(1). The state protection service shall have a director who shall be appointed by the president in consultation with the National Security Councils on such terms and conditions as may be stated in his letter of appointment. We know, say, we get public appointments committee, but it is not explicit because most appointments go say appointed by the president subject to parliamentary approval.
Correct.
Right? But in this way, the way the law is drafted, there's nothing like that. You don't have to assume it's not there. Because the president can say, well, we don't talk about the executive powers of the president, the president can say, well, I don't appoint this person, and on the guidance of the National Security Council, we don't state in terms of conditions of service. Parliament not going to interfere. But
And
since there's all public appointment,
doesn't the president appoint the committee? The president appoints the committee, doesn't he?
Yeah, well, he's head of the committee.
Okay. So all the appointees, he appointed them. So nobody is coming on board.
Okay, put it this way. The Office of the Security Council, the Secretariat, now the ONS, Office of National Security. The coordinators of their agencies, and they are subject to parliamentary approval as per the law.
Yeah.
But this, as I say, this special security service, when a new thing, be every day. The way they write the law, I go repeat them back. It said the State Protection Service shall have a director who shall be appointed by the president in consultation with the National Security Council.
And
right?
of which he's the head, and he appoints everybody.
And he's also the head of the National Security Council.
Yeah, correct. Okay.
On such terms and conditions as may be stated in his letter of appointment. Again, when they draft this law, when you say in his letter of appointment, you assume say, now man you go appoint. When you say in his letter of appointment,
yeah.
And when they talk about the gender bill, it has to be stated. If you put them properly for draft them, you will say in the substantive appointee's letter of appointment, where that means it cover both gender.
That's one way, but you could also put a slash and put she or her.
Oh, yeah, in his or her.
No, his or her.
Letter of appointment.
Mm-hmm.
Yeah. And this director may be the head of the secretariat, right? And now for responsible for the administration, management, operation, control of the State Protection Service. You understand? So now the president appoints him, now he's in charge of all NTR, and of course, he's not subject to parliamentary approval.
Bad law.
But I'll go further. How these people and they do their work? It comes under section 42. Well, they get a section under the bill. We start from part 8 of the bill. We talk about warrants and sting operations. Right? And I'll start from the beginning. It says where the Director General has reasonable cause to believe that a warrant is required. So now the Director General, I ain't forget that reasonable cause for belief say he need warrant for enable the agency for performing function. The law says it shall apply to a judge or magistrate for the issuance of such warrant. So in other words, if the director say he want kind of use, so he get intelligence say either they do bad thing and use, or they communicate with people that way na security threat to the state. He get for go to a judge or a magistrate for issue that warrant. And within that warrant they give the power. The warrants they give the power for search the person house, the premises, in computer, and any other device, or it can take in property, and then it can intercept in communication, right? Then 2, application under this warrant, it says shall specify the facts relied upon to justify that a warrant is required to enable the agency to investigate a threat against the security of Sierra Leone. So in other words, that warrant it get for state the fact. But for the fact that it get for go to the Director General, the Director General get for go to a magistrate for get that warrant there. And also it talk about the urgency of the matter. He say he go for that warrant day if he feels say not impracticable for carry out the investigation using other procedure. So in other words, it can bypass any investigation way like other institutions like the CID they do, or like we get the Financial Intelligence Unit, where something na investigation we them can do. But in can go now, the Director General go get a warrant day, right, for address them. So one of the things where before I go to that, I will go back to the Constitution, because if you do that, there should be a reference to the Constitution where it go say without prejudice. Because when we look at the Constitution, right, in Sierra Leone, Section 3, Chapter 3, when I the entrenched clause, it gets something where it relates to that. Where if any change from that, we for actually this law for refer to that change day within the Constitution, and I will make reference to that. Let me just find the appropriate section. We talk about things to do with freedom, where you cannot just go and put somebody in place without get right. Because if they talk about this new warrant, actually, it come under Section 22(1). Let me read that to you, sir. It says, except without his own consent, that is protection of privacy of home and other property. Now, so the Constitution say. It says, except with his own consent, no person shall be subjected to the search of his person or his property, or the entry by others on his premises, or interference with his correspondence, telephone conversation, and telegraphic and electronic communication. That is the right under the Constitution. So if you say now, then people here can get a warrant for do that, it has to clarify why Dande and the Constitution not make reference, why the law not make reference to that right in the Constitution. Let's stop there, let's see what you can say on this Tiwa race.
I was just going to ask you if you can read again when the group directed by the director applied for a warrant.
A warrant?
Okay, what are these? What does the warrant have to contain? Did they indicate?
Okay, let me go to that.
Is there any specificity? I know we'll get a call, but if you can answer.
Okay, let's go back to the warrant, right?
Yeah.
It's a warrant. Let's start by say, where the Director General has reasonable cause to believe that a warrant is required. So the Director General, I forget, reasonable cause to believe that a warrant is required to enable the agency to perform any of its functions, he shall apply to a judge or a magistrate for the issuance of that warrant. And that includes such premises, computers, and other devices or take property, which is in contradiction or violation to that fundamental right to a read. But let's go further. Yeah, it talk about the application for a warrant if we rely on facts to investigate. If we rely on facts, so now that's not the. Then it say effect of the warrant. It say any warrant under Section 40 shall authorize a person or persons to whom the warrant is issued. So in other words, an agent of this SPSS, where we get a warrant, it authorizes them to exercise the power for the purpose of intercepting communication, obtaining information, records, documents, or such other things as may be specified in the warrant. So the warrant now go get all them powers and then we get for use.
All right. If I may take a call, then I'll go comment on what you just said. Hello, caller. What's your name? Who's the call from?
Excuse me.
Hello, caller. Yes.
Now good evening.
All right, Mr. Mustafa.
I get some bit of talking. When I thank you for the program. Yes, well, now for the call from Leicester.
Yes, sir.
Thanks, Mr. Get me?
Yeah, we'll get you very clear.
Okay. You know, even when Mr. Kagu, they talk about the constitution and other things, them, I think we all know the level of, the control where the president gets on the state at this current moment. Where the way they make the law, then when they try for reform or they try for the constitution, instead of they reduce the powers, they try to add the powers. Today, the president, from all the powers that we get, we will not say 1991 constitution again too much powers. Now then they make another law. We didn't see back 9 for head up, 9 for appoint. You see how them politicians they look beyond their noses, they see beyond their noses. Because this man, they not imagine. Now I can tell Mr. Kabo say, we know say if them no more for reform the constitution or amend them, they not go touch him, they not go reduce the power to the president. That's why with the law that we don't go sign up to. If we force them for adhere to that, that is a start for law begin take some power from the State House. But no, where's the chance pass? Where's the chance pass we? That's why I see don't get the manipulate by because all the talk when they talk to now for manipulate the election is bad. They declare them say they don't win, they should don't run the state as one runner. And we see this one pass. We not go ever get this opportunity against it, they will reform more. Because that's why I go see don't make sure see they pass all the laws them. Where they make them sit down in power and consolidate power to the fullest. Now they will see you. We see what they talk see. What is the non go sign? Where this now go sign they would agree to this. Now they balance, they see the party they see they will not mix pandani. So now this would see say this president wouldn't have power too at this moment. The kind of person we will manipulate laws or a country. I don't think they will get that person there for the longest of time. So now we think who they talk about say more go no more. No we not gonna buy you know. Who say would they go now a war situation at 2023? And then people like who will see they're grossly incompetent. For continue constitutional power, we know for full and commodity, they pass all the bad laws. This intelligence law, they no say that they lead, that they win the president, in family, the other people are all they get they get security. That's what it is right now. So that's why any way we will get for put pressure. When people have do something to change these laws, or at least the one who don't go sign, now this is what they do. Let them put them into law so that we'll get small in them where we will hold them accountable. And that's what I want to add to the argument so far. I don't know the other topic I want to get to so far. I want to say thank you very much.
Thank you very much, Mr. Mustafa. We'll go take another call.
Oh, you get another call. I just want to make one clarification before you make that call.
Yeah. Go ahead.
Because I reference the Constitution. You go finally make the clarification.
Okay, go ahead. Okay.
Who said that law they were talk about the protection of privacy of home and security? Section 2, 22, subparagraph 2 say nothing contained in or done under authority of any law shall be held to be inconsistent with or contravention of this section to the extent that the law in question makes provision that is reasonably required. So the law therefore makes it say reasonably required in the interest of defense, public safety, public order, public morality, public health, town and country planning, or the development or utilization of any property in such manner. So in other words, what they say, even when they go for that warrant day, that warrant day therefore state clearly the purpose under which they go enter your premises for search, confiscate your property, or intercept your communication. So it is there. But the point I'm making is in making this law, they should have referenced this section of the Constitution for like very clear. Over to you, sir. We can take the next caller.
Hello, caller. Which name you name say to call from?
Hello?
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 Hello. Go ahead.
Yeah.
I hear you.
Mr. Sheila, Mr. Sheila, Mr.
Mengot.
Unakusha.
Yes, sir. Thank you.
Unakusha una the educate way. But I want to bring this calm to the notice of everybody. I want to make Mr. Mengot explain, although this is not to the topics for the day, but I'll make you explain for we will not understand, but let we get clarity. I want to let it tell we don't understand when Parliament dissolve, because Parliament is dissolved 3 months before the election. When it dissolve, who they control ECSL? Because ECSL always they say, nobody they tell them what you for do. In independent people. But there gaps wait on there. The time when the Parliament dissolve, we forget institution we go hold account we will give accountability. We know that get the car we get all the rope. We'll get the car for hold the rope for give accountability. What did they do during that period the day before? They announced the results. Because in the talk here, because good people they will get now their mind say, according to what in the talk, nobody know for controller, nobody know the controller. So we're gonna clarity today. Now we don't question that.
I think we will deal with that in the second part of this project, this broadcast. What they deal with ECSL.
Okay. All right.
Okay, over to you.
Because many people that they we don't understand. We don't get that.
No, we will deal with that. That is a part of it. Now the second part of this program. So let's try for deal with this. Yes, Mr. Shilon, as I go back, we talk about the issue of warrant, but the Constitution clearly claims, say, for enter your premises or anything, it give the time then way an authority go get for do that, and the reason. So my own question, my own issue is that when an agent go to a magistrate for a warrant, he get for the magistrate, we rest the judgment on the magistrate or high court judge for say irreasonable. The facts are there for that agent for carry out that surveillance day na your property. Now that's not the issue. It get for be clearly stated.
Okay.
There's a comment. I don't know if you want to read that comment before we continue.
You don't finish your thought because we'll go.
I don't finish the thought. So I just want to clarify, say, well, yes, in as much as the Constitution give the individual the protection, but that protection is subject to the law for clearly make sure, say, anybody where they go do surveillance on your property or put you under such control, for do them in the interest of defense, public safety, public order, public morality, or public health. So in other words, when the person they make application to the magistrate, again for make and clear why he need that warrant there for going to you host and for interrupt you communication. The discretion is left to the magistrate for give the warrant. The issue is the magistrate now get the final say. Once the magistrate get that warrant there, it can carry out in functions. That is what is in the law. Over to you, sir.
All right. Let me read this comment, then I want to take a call. One hopes the opposition parties challenge this motion in Parliament because if not, there will be trouble ahead. All right. Now, okay, before I go to a caller, make I just ask, Mr. Mengo, the thing, the law or this bill, they require that the director, before he
the director general or an agent or a staff where they work under him.
Okay, they'll just say the director or one of the staff, like you say. So then therefore, then therefore prove reasonable cause.
Yeah.
Apply for, okay, and then I think, yeah, for apply for a warrant, and I think you say there should be facts to substantiate or justify the application of the warrant for do certain things them what they think give them the power for do. So to me, what I'm saying, okay, sometimes drafting of then laws there can be very complicated, and sometimes no matter how you do them, it will get some ambiguity, it will get vagueness, it will get irregularities. So now, if we should be hearing things like, okay, then talk about reasonable cause, whatever that means to apply for the application. Then talk about facts, I guess facts that will sustain the justification for the application to be issued. Okay, but I think language like reasonable and articulable suspicion, because they say reasonable cause, would reasonable cause be synonymous or equivalent to reasonable and articulable? Articulable, a part of it is you get a reasonable cause in mind, but are you going to be able to articulate it to the magistrate in a clear and convincing way as to justify the issuance of the warrant? These are some of the language they will forget.
Mr. Shilon, hold your thought there. Let's be fair to the drafters. Yeah?
That's what,
because
no, that's why I said, no matter how you do them, you can never do them perfectly. Yeah.
No, but they state several things away for cover that. Now I specify.
Okay.
It said, A, the facts relied upon to justify that a warrant is required to enable the agency to investigate a threat. Then B, that the urgency of the matter is such that it will be impracticable to carry out the investigation without investigation using other means. So in other words, that's something we're very urgent, then can't do that investigation other means. Then it said without the warrant, it is likely that the information or importance related to the threat would not be obtained. So in other words, you get for proof, say, this is the only way it can get that information and then where they talk about communication, you get for talk about the type of communication, the information, the record, and documents where you rely on. I'll give you an example now. We already get the cybercrime unit. under the police where they monitor. So in other words, it get for make sure say that information the way they want from you through the warrant, he cannot get it from like the cybercrime unit or anything in it, you know. So what is the urgency of the matter? Now that protection they can, but who that get for determine all that? Now the magistrate. My question is the magistrate equipped or the judge, does he or she has such technical competence for determining those facts?
I think then that technical competence comes about as a result of the frequency with which matters of this type are brought in front of that magistrate or judge, because you get more cases coming before you, and then you make their assessment, and they say you get better at it, and then to some extent it could make you an expert, because some judges become experts on certain issues of law. So if we make it infrequently, then we get for balance that, as opposed to what you just read about the Constitution. I think the law must also indicate provided, there should be something to say provided nothing in these subsections will contravene Section 3 and all the rights associated with Section 3 under the Constitution or of the Constitution. Then forget it. So even that, no matter how you frame them, there is going to be imperfection, because it had for craft a statute or a law will cover all the activity in there. So it's when the actions are taken in good faith, the Director General in good faith and in the spirit of the law applies for an application to do a search of the nature described here, or for a warrant, to apply for a warrant. Okay, in good faith.
Okay, I just want to make one continuation. I just want to make another continuation where you go deal with them. Then we will get the color. Under Section 42, when I am me concerned about now, it said the Director General may, without a warrant, listen, may, without a warrant, request an institution in writing for information on a person or group of persons if the circumstances are of such seriousness and urgency that the national security of Sierra Leone would be greatly compromised. So he also give the Director General power for request information.
For circumventing. Yeah, that's what it sounds like to me.
Then I don't understand. Because you get the warrant where they require for get them. Then they talk also about getting power for obtaining information without a warrant. That is an oxymoron.
Okay, it sounds like it. You remember that's what happened with I think the Constitution on the Census issue, when there is some, but implication is not even written that their census shall be every 10 years. But it's a generally held belief. But then they come back and they say, but the president may. You understand? So this law can put all this ingredient in something, then will come back and say, like they say, the Director General may, which seem for strip all what they just say about the application, the thing and for follow. The Director General can circumvent all of that. It seems like. Why not leave it the way it's so tightly put together, leave out the Director General may, and then let the event unfold, and the laws can be straightened as events occur. Because you're not going to be able to draft a law that will compose of everything. I mean, it's not going to happen. It's when the courts get involved, and then there's going to be some interpretation of what the law might have meant, or what was the intent of the law. That's when we begin to shape the law into how it will serve the country. The danger is if all these are being done, like we talk about Director General having the power to do all their activities there, I think this is under the sting operation thing it looked like, because they mentioned the word sting. The NSF is definitional. We're going to come up with what a sting operation is, what encompasses a sting operation. Now, I know say sometimes you got to give law enforcement that power there, that flexibility there, because if the contraband is stationary, I mean, it's transitory, meaning it's on the move. I get tons of cocaine in my motor car. I'm on the Freetown Highway. So that calls for a different circumstance and different approach, because the subject matter, the contraband, is transitory, it's moving. But the same exigent circumstances they exist when the contraband is kept somewhere where we know with proper procedure, with no urgency, the contraband can be found. This is where good intelligence gathering comes into play, which when the China will be focused on, for improve the quality and efficiency of intelligence operation with CID, but not to forgive CID the power for begin invite people and come and you detain them at the CID, turning the countries gradually into a police state, and people just let it happen. So these are some of the things. But no matter how it's done, it's going to be the courts that then get the expertise for coming to the final outcome, some of which we may not like. But if it goes through the process in good faith, I think everybody can live with it. This inference that there is political overtune to some of the laws that are being drafted is bad for the country, and some of which is clearly, you can see the intent of it. But we still haven't addressed, but we don't bring up to we talk about this special protection force, and we still not too clear on it, because I think we're in job, and for those people I know say there is protection which seems to be adequate for the president, the vice president, and others. So why do they need a special protection force? What's wrong with what they already have? These are some of the issues that we'll get for raised. And but just let people be aware, because some people don't even know, say there are efforts afoot for get extra power. We may not be necessary for now, maybe the future, and then how all of that fits into Section 3 of the Constitution in terms of the protection, individual right, the protection of individuals. So it's really, I think this is not the kind of law where they're not for just rush through Parliament. It should be debated, and ample time should be given to all sections of community who are interested in it. If they begin rushing, that also in a good indicator that it's being done in bad faith, because it's not being done for any good purpose, but for just empower the other side. And we have to be mindful that if an election is coming in 2028, because I get one question, but why I always want to ask Mr. because I've never been able to understand when you talk about national unity. I think somebody needs to explain that thing too. Does national unity mean we have to agree on everything? What do national unity entail? Because Sierra Leone is regarded as one of the most peaceful countries in the world, So what does national unity mean? I probably go ask Mr. Mengo that, but I haven't seen a definition. But it looks like there's so much effort is being put into this phrase, national unity. Does national unity mean...
Before you go further, we'll come to that. You mentioned one thing we're also very important in this law, where we'll clarify. I think say this sometime. You talk about sting operation.
Yeah.
Right? Yeah. And I'm looking at the preliminary, because when they draw an act, when they draft a bill, in the preliminary section of the bill, you go define them terms here. But there's no definition of what a sting operation is. But here is what it says. Under section 43(1) of subparagraph 1 of this bill, it says, where the Director General believes that a person or group of persons is intending to or is already engaged in an activity that constitutes a threat to the security of Sierra Leone, he shall give approval in writing, copied to the National Security Coordinator and the Inspector General of Police, for a sting operation to be carried out for a specific period if it's impracticable to collect such information or intelligence using other investigative procedures. So in other words, with sting operation, you don't need approval from the magistrate to a warrant.
Yeah, it sounds like a warrantless. It sounds like a warrantless.
It's warrantless.
Yeah,
it's a warrantless job. That's not the thing. And then the final part of it is say under 43, he also gives the Director General immunity. He said, notwithstanding any enactment to the contrary, a person or class of person approved by the Director General under paragraph shall not incur criminal liability for taking part in any such operation in accordance with the terms of the approval.
Well, that speaks volume. Because with all this construction, where we see now, you say, but basically, paraphrasing what they're saying, basically you're saying, despite all of this, the Director General is free to break the law without due care and circumspection, and will not be held accountable civilly for breaking the law. So despite the fact that all these requirements are set for the Director General and subordinates for comply with, but if they fail, which you can just deliberately do, just fail by inaction, and then any consequences such as some harm done to someone, the law says the Director General cannot be held responsible or accountable, you know? So doesn't that defeat the purpose of all this thing within the talk about?
But then the interesting thing, the following section deal with complaints, a tribunal complaint. Even though it exonerates them, it says a person who is aggrieved by anything done by the Director General or any other officer of his agency in the performance of his function shall within 12 months submit a complaint in respect thereof to the minister. Then the minister, not a judge, not the court of law, where the complaint is direct, is against anything done by the Director General. Yeah. So nothing there where tell you say, then he said a person who has made a complaint under subsection 2.1, no act. He said if any action not taken and is dissatisfied with the action taken by the minister or the Director General, as the case may be, he will submit a written complaint to the Chief Justice. You see, in other words, he's saying, the law is saying, let's say when they talk about sting operation, say you get 2 Mohammed Kuruma within a one street. Then go to one Mohammed Kuruma but a different address. Then later on, for them broke yours, everything. He get complaint. He get a complaint to the minister, and who then the minister? According to the law, the president can appoint any minister for supervise the SPS, not a particular minister. Then when you go to the minister, if the minister no answer you after 12 months, now that time you get to go to the Chief Justice, not go to a court or sue them. Now the Chief Justice now you get for complaint to. Then they said when the Chief Justice get you complaint, it appoints a tribunal consisting of a chairman who is a High Court judge or retired High Court judge, a lawyer who is qualified to be appointed to the High Court, and 2 other persons, one of whom shall be a person with extensive knowledge of the issues in the complaint to hear and determine the issues within a period of 30 days. So you see, it's at the discretion of the Chief Justice now for appoint a tribunal with 2 other persons for can deal with the case. So if you are aggrieved, complain to the minister. If you not get right, if the minister not give satisfaction, you go to the Chief Justice. The Chief Justice there now appoint a tribunal, right? But then, why you not say you can go to court?
Precisely. Why you not give you the option? I was thinking about it. Well, I mean, the right to complain, in fact, under good governmental structure, the right to complain to a manager or someone in a supervisory position, now administrative matters, they become administrative. What I don't seem to understand, I see Sierra Leone then keep busy to drag the Chief Justice into all kind of procedure where the Chief Justice should not be involved. Even in this suggestion now, the Chief Justice should not be involved because this is a court matter. So the matter might come before the Chief Justice at a higher point. So why drag him into any controversy at an early stage? Now, it's okay to set up administrative procedure whereby someone may not choose the court system because of the inability for higher counsel. So he might proceed administratively. But now, like the word, but then we can see clearly, you can complain to a minister, then just put it on the shelf. And then say, if you're not satisfied, after 12 months, you can take action, which is more than likely that's what will happen. They will just put it aside, let the tournaments run, and see if you can forget about the complaint. Or if you want to pursue more, they still at this stage haven't given you the right to sue. Instead, they say, go to the Chief Justice. Well, the Chief Justice only participates on judicial matters. The administrative matters down there, why then they pull them from minister, then directly you go to a Chief Justice when are part of another branch of the judiciary. The process is just flat out wrong. I don't know what you think about that.
In fact, it's saying, the interesting thing is say, when the Chief Justice get this tribunal, when a retired judge or any other person, then it said the rules of the High Court shall apply to proceedings of the tribunal with such modification as shall be necessary.
What is this? What's
Exactly.
interference on my screen?
Huh?
Oh, I know I'm getting a lot of interference on my screen. I don't know how that happened. Yeah, well, go ahead. I can hear you. Yeah.
So they say now the Chief Justice, this tribunal where they set, the rules of the High Court shall apply to the proceedings of the tribunal with such modification as shall be necessary. So if you talk rules of High Court, right, then you say modifications.
Then you want to modify the rules of the High Court. I don't understand. What modification are they talking about?
Exactly.
You know, and then besides, we don't need a tribunal to be set up by the Chief Justice, because here we are, they are talking about a lawyer, a judge, a retired judge. These are all not being done for free. Am I wrong or right about that, Mr. Mengut? People are being paid for then tribunal there for their service, not so?
Yeah, they're paid for that.
Yeah, why is a tribunal necessary? Why does the matter have to go to the Chief Justice at the premature? Let the matter take in regular course. If it will meet the Chief Justice, let it go through the judiciary. No tribunal needs to be appointed, you know? So no money needs to be spent. Then the Chief Justice shouldn't be involved in cases prematurely. We're not in the judicial system. Why zigzag the system? First you go to a minister, then you send them to the Chief Justice, a part of the judiciary, then you bring and come back. It just not make any sense. But this is what happens if the laws that are to be passed are not being done in good faith and with such clarity as to make governance efficient. This is what will happen, because you get drawn into trying to make the law sound so punitive, you know, that you're not go able to balance them, because if you want to try for balance them, you're not going to affect the people in the way you want for unduly affect. You see, these are some of the things that we will talk about. So we need to understand that, and then the press is has been weakened so badly that the press itself not raise some of the issues that we would raise. and they raise them, but not as effectively as it should be. But one thing people need to understand, all the issues that were raised, now for the good of the country. I know some people and think say the country is a political party. Some people and think say the country is a political party in power. But we are saying, no, the bigger picture, that the people who comprise the country, because the country is not a piece of land. Now, the people now make the country. So how do you protect these people? You can't just take the freedom of and the protection, the right under the Constitution for protection of the property. You can't just take away the speech. We're claiming that we get democracy for the satisfaction of just a few. We can't just claim the right of movement and take it away from them. So these are all things we have to consider. So anything we do must be done consistent with the provisions of the Constitution or sections of the Constitution. If we're not doing that, we are spinning our wheels, we're wasting our time, because otherwise in 2027, 2028, we'll be repealing a whole act again, because we'll go find more good new rooms then for add more to add. But now the addition could be so many, we say, no, don't just repeal the existing law and draft a new one, as is about to take place with this act within the time for bringing to Parliament. So then this whole thing about the application to obtain a warrant, good provision. But then say for reasonable cause. How do you establish reasonable cause? That not only the courts and the lawyers them, but based on the facts and in presentation, they go shape the law. So the face of it, maybe this is sufficient. But then at the magistrate now, or the judge, the magistrate in particular, they go get for ask them, dive into the whole matter and say, well, okay, what are the facts here? Why will not do this, will not do that? And justify the reason or the issuance, the justification of the issuance of the warrant for someone to be searched. Because otherwise, these things are subject to abuse. I said it before, and I'll say it again. A constitution for a country is set to put perimeters or boundaries on the power of government. And the same constitution is set up to protect lives, liberty, property of people. So the constitution is primarily therefore put limitations on the government, not give the extraordinary unchecked powers, while at the same time put limitation on them and not for abuse the right of others, of people, particularly the right of movement, speech, association, and all of that. That's what the Constitution generally is set for. The legislations them, or the bills, now they give the nuances, or they give the nitty-gritty of what that section they will guarantee freedom of association, freedom of movement. And sometimes it will only come about when there is an issue before the court and the lawyers then ably argue the points. And then sometimes the court can be mistaken, but at least you will see the good faith attempt to make the law workable and protective of everybody. That's what I have to say. The spirit with which these laws are being proposed is what I'm concerned about. Because when we start trying to call national security and central intelligence bill, we're beginning to sound like America, Russia, China. Are we so burdened at this stage that those are priorities? I'm not sure, or are these bills coming up just to oppress the other side? And the other thing people need to realize, a democracy is not proper or real if there is no manner in which an opposition can be a likely replacement of the existing government. Any laws passed should be such that any given time an opposition can win through fairness and come to play. So any law would pass that for undermine the opposition take away their ability forever kind of power, we're hurting the country. So these are all the things. If we say we have a democracy forget an opposition at any given time can replace the existing government. And we're seeing it happening in Ghana, which is again in our region. You see, we're seeing it happen in East Africa, Kenya, and then present day. We see it happen in Liberia. You had the Salif government. You had the Weah government. Now you have the Doumbouya government. I'm sorry, not Doumbouya, it's Guinea. Now you have the Bouaké government. Okay, all these and by democratic means. We have not had much complaint about rigging of election. That's a healthy thing for the country. And no party should come to power with a determination that the other party should never, ever come to power because it hurts the country. Because once you get that comfort, you get in that comfort zone where you say nothing can happen to me. Of course, you start doing things that are hurtful to the country because accountability is gone. So I'm not so sure. And what the party now in power is doing, the other party did it. This is the amazing part of it. So I'm just simply saying, let's be careful how these laws are being proposed, how they're being passed, and how they're being drafted, because it will come back to haunt certain people who are the makers of this law. Like I said, the Zainab Sharif case, you see what happened? They got rid of a well-tested, constitutional a legal theory about a jury trial. Could not test that. System would last for centuries. We just come. We're not even trying. We're not doing any pilot program. You can tell, say it was made in bad faith. Then get rid of them. Now with a complaint, about too much power. This is the thing. Why are we replacing all them good protections here in the law with bad laws? To this day, it makes no sense for replace the jury system with the existing system. There is no way that can be just, just because you get the power, So
I
let me
think
just.
Yeah. Okay,
No, go ahead. No,
I don't know if you want to take another call, because what I wanted to say is just to update, let people then know whose side is bill on day. Then, because we get time, we won't go into the other second part of the program, because we'll continue this discussion. Because this bill, it gets a lot of things to do with individual freedom, things to do with financial things for the government and choice of personnel, because these are all security issues which should get more and more citizen participation.
And expensive too. Let's propose this bill to be very expensive.
For the time being, the bill don't go to first reading, it don't go to debate, they don't send and go committee stage. So after the committee stage, it come back in the parliament, the speaker say, let them go look and behind closed doors. I don't know what it means, but I think, say, in fairness, this bill should be sent out like the constitutional bill where they ask for public opinion, position papers, and therefore put a halt to them until the opposition self cannot back in the parliament. But for now, the bill there within the confines of parliament is still in at the committee stage. It is not yet finished. We will continue for alert we viewers them and other issues and they will get for look into this bill where relates to parliamentary scrutiny, because that is very important. So we'll do a follow-up next week, where by then we hope say the opposition will not go parliament. And so, with your permission, I want to go to the next segment. We come back with what you be asked for, what they mean by national unity. And these are so-called moral guarantors who came to Sierra Leone and get some issues them where they put, say, we for look into.
Okay,
All right.
go ahead.
Okay, now you talk about agreement for national unity, peace and national unity. This was an agreement signed between the government of Sierra Leone in the form of the president and in challenger in the last election, who was the flag bearer for the APC, Samoa Kamara. When at the 8-point agreement, part of the requirements, you ask national unity. When you talk about national unity, peace and national unity, first of all, you talk about peace where there is upheaval. Did we have any upheaval? What we had was a dispute between two main parties in the parliament. So, and call them peace. National unity for say, how them parties will come together and make sure say they work in the interest of the people. So the main bone of contention, now that tripartite report where they produce. What do they mean by tripartite? Tripartite means say, because when they argue, it means say the government, the challenger, and the moral guarantors, and then three come together. So, but before we go for put it in context, when the moral guarantors there come, they may meet several people there. They meet the president, they meet the chief justice, they meet the chief minister when I ended at the government side for the implementation. They meet the APC party, they meet the SLPP party before they issue a communique when some of them think and they want to board. But before for put the ball rolling, if we control room can play the first video for we, where then go meet the chief minister when I in the head the government side for the implementation. Then they go put it in context. They go followed by waiting the SLPP party themselves say in response to one particular issue where now the independence of the ECSL and the reform. Control room, over to you, sir.
Well, by showing our continuous support of the international community to the implementation of the National Unity Agreement. As I always say, by showing our continuous support of the international community to the implementation of the National Unity Agreement. As I always say, we have to take Africa and work Africa. We have a lot of issues that are happening in the world today, and the agreement, as we implement them, must take into consideration things that are happening in the world.
With evidence independently done from the Peace Commission, and I say this with due respect and with data and facts to back this up. We have done 100% of the agreements for national unity. Resolution 1 of the agreement for national unity, and I will read verbatim, said His Excellency the President to make a national address on dialogue, unity, cohesion and peace. His Excellency has done this dozens of times. He has done it immediately after this agreement was signed. Resolution 2 says that APC will end its non-participation in governance. That was done. Resolution 3 says His Excellency, in consultation with the APC, will constitute a cross-party committee on electoral systems and management bodies for the three-way leadership nominated by the government, the APC, and development partners. Full stop. That was done, and the resident coordinator was the co-chair. Dr. Guy Mahia was the co-chair, and Dr. Kefala Mara was the co-chair. Second sentence in 3, this body will examine the electoral system, structures, and processes of the 2023 CTI electoral cycle. That was done. And 3C, the recommendations from the committee shall be actionable and implementable. All 80 recommendations were actionable and made and implementable. Many of them, as I'll update later on, have been implemented or are being implemented. the tripartite recommendations as from the Agreement for National Unity, 100% done. Resolution 4 was the parties to release any persons arrested or detained. Some of those people ran away during the failed coup. Others were tried for treason for the coup, and the rest released. So 4A done. 4B, discontinuation of any politically motivated cases. Some of them, like the mayor of Freetown, had an obstruction of justice case with one of the councillors, clear obstruction of justice case at the airport, security issues. That was removed, even though this was not a politically motivated case. 4D was that we should pay back laws. Parliament made a case, and we paid them. Council made a case, and we paid them. I want to assure you that this will not happen in the future. Anybody who is not entitled to a benefit will not get a benefit. That is not right to the people of Sierra Leone. And this is important, so everybody knows this. This agreement that we had done was a concession that we made, and we're happy that we did it. As peace is important, but we cannot repeat this moving forward.
Okay, sir. Let me put this in context, right? What will be here so that the chief minister, the time way the moral guarantors them, bingo meet them. And for we listeners them, Lord tell them, other than these people them, we be form these moral guarantors, the winner, the key people them, right? We been get the lead international moral guarantor now been Her Excellency Fatoumata Jallow Tabajang, when have been former Vice President of Gambia, representing the ECOWAS, because normally ECOWAS na the regional body. We get His Excellency Barry Freeman, when I the Deputy Special Representative of the United Nations Secretary General Office for West Africa and the Sahel. West Africa, then we were the ECOWAS Sahel, include countries like Guinea, not Guinea, Mali, Burkina Faso, Niger, the continent where they between mainland West Africa and the Arab country then, so now they will call Sahel. Then you even get the ambassador from Ambassador Tamaya Lyle, when a Deputy Secretary General of the Commonwealth. So now then people here can say, okay, in a binonge agreement, right? Draw been come. But waiting now the thing will cause all this problem. When they get the agreement day, according to the Constitution of Sierra Leone, because me I can always like for go na Constitution. The Constitution of Sierra Leone define agreements them where the president, who is the fountain of honor and justice and symbol of national unity and sovereignty, for sign on behalf of the government. So it say under section 40, subsection 3, we say the president shall be the guardian of the Constitution and the guarantor of national independence and territorial integrity, and shall ensure respect for treaties and international agreements. So the president goes sign. Where he goes sign, it means where he goes sign, is signed on behalf of the government of Sierra Leone. And once you don't sign, right, the law say any treaty, agreement, or convention executed by under the authority of the president which relates to matters within legislative competence of parliament. So in other words, this agreement, it deals with matters we talk about parliament. It also talk about the law of Sierra Leone, waiting at the law. Because inside the tripartite agreement, they talk about constitutional laws them and the reform of the constitutional law. They also talk about reform of laws for the Republic Elections Act and PPRC Act. So what they should have done was them if I put this agreement to Parliament and Parliament ratify them. Once Parliament ratify them, now that then go act on this whole thing. So it comes back to one of the first 201 talk today, where now they bring more controversy where the SLPP party not agree with. Then under the agreement where it said, one, the government for engage the government meaning executive, the leadership of parliament to urgently constitute the parliamentary standing committee. That committee there, if that agreement they been go parliament before appoint that committee there, we clearly say the committee should be headed by the opposition for looking to electoral reform, constitutional review, and legal reform. That is the bone of contention. Even though the two parties they agree, because when the law go before, when they form that committee, they set the pace. But that did not be happen. President now decide for set up a steering committee and a secretariat. Now then they complain back. So the moral guarantor say, let us go back to Aina for start. Right? Put the agreement before parliament, set up the committee, and laws waiting to happen. But before we go further for discussion, let control room play waiting at the SLPP party their own response. Then I go and let me colleague Kamlo talk about this. How important it is for this agreement for the parliament and for set up this committee.
News, gossips, facts, trending wahala, we get them all. Welcome to Onboarder TV.
The Sierra Leone People's Party, widely known as the SLPP, has expressed deep appreciation to the international moral guarantors, including ECOWAS, UNOWAS, and the Commonwealth, for their continued commitment to peace, stability, and democracy in Sierra Leone. In a press statement released on the 21st of April 2026, the ruling party gave special thanks to Her Excellency Fatoumata Jallow Tambajang, the former Vice President of the Gambia, whose leadership has played a major role in guiding the peace and reform process from the very beginning. The SLPP stated that President Julius Maada Bio, as leader of the party, remains fully committed to implementing both the Agreement for National Unity and the recommendations made by the Tripartite Committee. Following a review of the 8 key points outlined by the International Moral Guarantors in their statement of April 20th, 2026, the party stressed the need to fully respect Section 32, subsection 11 of Sierra Leone's Constitution. According to the party, this section clearly states that the Electoral Commission of Sierra Leone must not be controlled or directed by any person or authority while carrying out its constitutional duties. The SLPP argued that Parliament should not have oversight over the administrative and professional operations of institutions that are protected by the Constitution as independent bodies. The party explained that just as Parliament cannot directly oversee institutions such as the Judiciary, the Anti-Corruption Commission, and Audit Service Sierra Leone, the same principle should apply to the Electoral Commission. The SLPP also welcomed the decision to expand the Tripartite Steering Committee to include other political parties and civil society groups. According to the party, meaningful electoral reform must include different voices and perspectives and should not focus only on the concerns of one political party. On the issue of the electoral system, the SLPP praised the international moral guarantors for respecting parliamentary procedures and the authority of Parliament regarding the Constitution Amendment Bill of 2025. The party also reaffirmed its strong support for proportional representation. Speaking on the ongoing population and housing census, the SLPP said it remains committed to working with all political parties, including the main opposition APC, to maintain constructive engagement with Statistics Sierra Leone. While welcoming the APC's decision to end its boycott, the SLPP urged the opposition leadership to adopt a more responsible and mature approach to governance matters. The party said repeated boycotts and threats can weaken democratic progress and undermine the constitutional role of political parties. The SLPP also restated its zero tolerance for hate speech, incitement, and abusive language. In conclusion, the party said it remains fully committed to working with all political parties, including the APC, to advance electoral reforms, strengthen state institutions, and deepen democracy in Sierra Leone.
Thanks for watching.
Yes, sir. Do you want to go? You want to go first, or you want me to decipher the whole thing?
Decipher the whole thing. Let me leave it up to you.
Okay.
Our comments.
Okay, let's listen to what in the party say. Now, 3 issues come out of it, right? Number 1, the SLPP party say, according to their statement, they feel say Parliament not for interfere in the operation of ECSL, but now a narrow interpretation, because then quote section 32, subparagraph 11, where say in the exercise of any functions vested in the Constitution, by this Constitution, the Electoral Commission shall not be subject to the direction or control of any person or authority. So the function where the Constitution give the Electoral Commission, now for conduct election, and where they conduct election, you get for compile voter register, you get for determine issues to do with constituency boundaries, you get for determine issues for deal with polling station, procurement. Then they do them based on the mandate given to them for conduct election. But then in terms of the accountability, they are answerable to Parliament. Because if you look under subparagraph 12 of the section 32 and quote, it said the Chief Electoral Commissioner shall submit a report on the program and work of the Electoral Commission at least once a year to the President, and a copy of such report shall be laid before Parliament. So in other words, even the function where they give them, they get for put under the strategic plan. That strategic plan they get for go through Parliament. Why? Because now Parliament they allocate and approve finance for their function. So if they put budget, they get for go through the Ministry of Finance, and then they get for go through Parliament. So you cannot say Parliament not forget oversight. Then I'm a false argument. The second argument where then they say Parliament not forget control over or for set this committee, because this standing committee where they say for set, now for monitor all length here, and it clearly states now the agreement of the tripartite agreement say it should be headed by the opposition. So you cannot say Parliament not get right for set that committee day. And I again refer to the Constitution. We're down there, now section 93 of the Constitution, when I give Parliament power for set up standing committee. And what is section 93 say? It says Parliament get right for the purpose of Parliament get the right for set up any committee, because it said, and in addition to this standing committee, Parliament shall appoint committees which shall perform the functions, right, specified in the next paragraph. What's in the next subsection, the 3, it says it shall be the duty of any such committee referred to inquire into activities of such ministries, departments as may be assigned to it, and such investigations or inquiry may extend to proposals for legislation. So if you take what do they talk, proposals for legislation include the constitutional review bill. You also include the amendment of acts like the Public Elections Act, the Public Election Act, the Political Party Regulations Act, and all act for those elections. So that question they not all water. Secondly, they agree with the PR system because it suits them. They talk about the parliament for do the PR system. But the same agreement say we get to think about which kind of system for use. You understand? Then the final issue we are going done with, now when they talk about census, right? And I go read waiting at the agreement with census we they agree with. Then I will talk waiting there at the parliamentary the bill. Then talk say therefore urgent they go work with all people them for make sure say the census take place. That is now the agreement number 6. They say on the ongoing population and housing census, both parties agree that census data is primarily used as a development and governance tool as well as for election purpose. But to be honest with you, what I would like for say, this census where they want go pan, they're not going to use them for the 2028 elections. Why? Because the constitutional amendment bill clearly say, it says that under section 4, where they talk for repeal, the agreement there for PR, it said provide, it talks to the census, what they do now. They say provided that for the purposes of determining the number of members of parliament to be allocated to each district and for any subsequent appointment thereof, only data from the most recent decennial census shall be used. So in other words, they cannot use the census data where they want do after the 2026 census. And then he continued for saying D, that provided that there were a final report of a decennial census is published at or less than 24 months before the general election, the data collected from that census shall not be used for determining the number of parliamentary representatives for the general election. So in other words, even the census data where they look, they cannot use it for the 2028 election. It can forbid the next election. So on the one hand, the SLPP party, they accept what is suitable for them when at the PR system. Then they reject the standing committee, where for look after the whole change. And they also get problem with the restructuring of the ECSL. So even though now the two parties then go under agreements there, the moment where the guarantors then turn them back, then begin to go. So I don't know what you feel for that. I just like clear this thing and explain it to people then, because it will be an ongoing debate. Over to you, sir.
Well, I think the basis of it, because like I keep emphasizing, is the fact that they are not acting in good faith in trying to reach a more objective result or compromise. Everybody they try. I mean, there's nothing wrong in trying to get advantage over the other, but when a document is being drawn for the betterment of the country and for the future, the central goal or the compelling drive should be trying to achieve some objective result in good faith. We will not say it will be perfect, but here it seems to me that's what the problem is. The problem is people are not pursuing these things in good faith, and the governments don't have the courage. The governments, when in power, will want to take advantage of every anomalies, every weakness of the law, which we call loopholes. Okay? So I'm not surprised that they get drawn and get this thing back and forth with the going between them. Okay, since we're almost out of time, let me take a call. Hello, caller. What's your name? Where you call from?
Yes, sir. Now me again, sir.
Okay. All right. Go ahead.
I thank you for go through that bill for security, because me, as usual, because I don't get any hope, see, the past governments and the current governments, they do anything good. I don't pay attention to all of these things, but I know say most likely the manipulation go they. And in this case, likely, rightly so. So you see, we only talk about the 1991 constitution, the contradictions, the way they did. How they can make in 2026 a bill even more contradictory than the 1991 constitution? You see that we on states, the one they would the rule way. They're not getting no intention for move this country forward. Other people who they say they make new laws them. They make laws the way they, march towards the 21st century, or also for much Western countries, they would work out all these democracy towards that they look forward to. But you just continue for the day maroon around the wrong things there. But at the same time, you will talk say you want this country to go before. How it could be possible? When I think again, because I not be listening to all this here, I just know say that is not necessarily number one, not the priority done for the country. This is not the priority for the politician. And now you go take again, it twist and twist and twist and twist the whole issue. Take power back, put it and look what it go complain to Chief Justice. Just like now, they go take the person they sentence are wrongly, now they be for big. How this person go before? You see what they talk about the law reforms? Now we make law the way they take power from the president, and we'll see opportunity for grab land through the agreement that they signed to. Let the whole world push the violent one, because if you come to them, if you depend to them, they will not do anything who will take away any power. Look today, they go and quote the rubbish 1991 constitution and then they quote this, quote this. Also the same constitution you don't broke. When I tell you say where somebody lost election, after election matter, after 4 months, they know it again. Matter in case not 3 years later 9 in Georgia, the parliamentarian they not 1 year past, they go put them common na parliament. Push they say where somebody them put them in parliament, they make a by election na do am. Not today na law abide party. States country don't for go before. If we not stand up to these people, if we didn't want to listen to them, no listen to them say, you know, na law abiding citizens them, my brothers them, my sisters them, this country not go before. Lot of fire for this net. No, thank you.
Thank you very much, Mr. Mustafa. Thank you. We appreciate your comments. Now, Mr. Mengo, let me go back to you. So, if there's a topic you want us to discuss, because we hardly ever have enough time to cover all what we want to cover. We are out of time, but if there's a topic you want us to continue, which the, of course, consent of the control room, we can move on. I don't have any problem with it.
Well, I think we've just highlighted where are these areas of controversy. You understand? Because the areas of controversy, one, now the use of the census data. We don't see say, but another key important thing where I mentioned just to finish, because we'll continue this one. One of the recommendation we've been doing at this communique, because it talks about these two parties, and I read them back. Recommendation 3. It said therefore constitute a team of legal experts on constitutional and legislative reforms with representation from the APC, the government, and other relevant groups. So if now you forget this legal expert on constitutional and legislative reform, does that mean they will continue with this constitutional bill in Parliament, because the bill already gets in first reading, it wait for a second reading for debates and voting for get the required 2/3 majority? Why is it only now Then they say for constitute both party experts on constitutional and legislative reforms. Was that not what they should have done in the beginning?
Yep.
So it's like we they put 1 foot forward and 2 steps backward. So this is not just one of the things then, but I'm sure so we'll get time to delve into it, because for now, long wait for see when the APC then go back in the parliament, because they don't put condition. For go back in the parliament, then they talk about 1, for table the agreement before parliament, 2, and for set up this standing committee, where I don't rightfully justify say, parliament get right for set up committee for do anything, be it legislative reform or for vet any ministry, departmental agency, or any other agency. Because by right, the electoral ECSL, if you want to look at in parent ministry, now the Ministry of Political Affairs and Political and Public Affairs. So, Parliament get the right for oversee that ministry and every agency where they under them. So this idea when they say Parliament not for look into ECSL, the other thing when the key issue now when they talk about restructuring and reform, what does that mean? So there are more questions than answers. We will get more time to delve into it, but if one go further, I think so we don't go really far in this broadcast. We will continue the broadcast next week, and we hope say by next week the APC go don't go in the parliament. Let's see if they not go it, then we will continue to talk about this. Over to you, sir.
All right. Thank you very much, Mr. Mengot, for your able contribution to making us understand or helping us to understand governmental activities, as well as how you can get a productive outcome of objective activities by people in government. So I hope we are looking at in the short run, the benefits or and disadvantages of what action is being taken by Parliament, and of course, and that then goal will be for achieving in the long run what we think will be in the best interest of the country. So until then, without adding more to the already extra time we've taken in making a presentation, I say good night to everyone. Thank you for listening. Hope we'll get some. We do have some benefits by getting you people to listen and participate. I hope you people listening also get benefit out of just the program today, and hopefully with the interest of tuning in to next week. Until then, good night. Mr. Mengot, I don't know if you have anything else you want to say.
Now, all I have to say to people, good night and thanks for participation. And as we always say, anybody will feel to say they get much for discuss. This is a national issue. Let them continue to send in their comments whilst we broadcast, or feel free to phone. We want to engage the public. Yeah. So with that, I wish you all a fruitful week.
Yeah, thank you. Are you looking at the comment? Is that what you're looking at?
Yeah, the comments.
The short one is, the person is just saying, I'm learning a lot here. Thank you for providing this education.
Much appreciated to that person, they will make that comment.
Yeah.
Mama Salon, we like you.
Welcome to VOS Social Media Review, your weekly platform for insightful discussion, bold analysis, and the stories shaping our society. Join lawyer Shilon and engineer Mengot every Sunday at 8 p.m. Sierra Leone time, streaming live on all VOS social media platforms. Stay informed, stay engaged, stay connected with VOS.